Thank you, Mr. Speaker. I think it's interesting that we're debating this bill for the first time in Parliament 1 day short of a year after its introduction. It was introduced on the 18th of September 2012. We're here today, 17th of September 2013, and this bill is being read for the first time. Mr. Goff made the point that the National Party campaigned on this, or campaigned on the suggestion or the proposition that legislation of this nature would come into the House if they won the election, which clearly they did. 2 years on, despite the implied urgency of legislation like this, the apparent urgent necessity for it, it has taken them 2 years to present this, to bring this bill to its first reading. And I think that's worth reflecting on in terms of the motivation behind this bill. All sorts of extravagant and wild things get promised and said in the heat of an election campaign. And I do feel that the legislation reflects more a political than a principled position in terms of its provisions, in terms of what it seeks to do. At the time a year ago when this bill was introduced, we were assured by the Minister that it was intended, that the orders were intended to be protective, not punitive, that it was not a form of double jeopardy, and that offenders would have as many civil rights as practicable. And that's a really interesting qualifier to put against the notion of civil rights, that they would be assigned as many as were practicable. So 1 year on, we are looking at this legislation, or debating it for the first time. And again, we cast our minds back a year. When it was introduced was around the time when there was a great deal of attention being paid to the release of one offender, or the form of release, of course, Stuart Murray Wilson. It was, at that time, there was an extraordinarily irresponsible display of media reporting. There was an extraordinary level of sensationalism about that single case, and I do think that that, in a sense, paved the way, potentially, for legislation like this that, in the Green view, does significantly overstep the mark. So one needs look no further rather than the regulatory impact statement. And right up front, some of that talks about some of the constraints on the analysis done by the officials whose job it was to prepare that statement. They make the point it's not possible to accurately report recidivist rates for such a small and unique subset of offenders. They make the point that impacts arising from other initiatives, and they mention the Sentencing Act in 2002 that significantly expanded the criteria for preventative detention, may reduce the need for the proposed measures over time. It's pointed out that the options, rather the provisions in this bill as they have evolved, are likely to override fundamental common law principles, specifically the principles in favour of liberty of the subject, that the law should conform to both international law and treaty obligations, and that we should avoid statute and regulations, or rather we should assure that statute and regulation operate prospectively and not retrospectively. So the point has been made that this legislation is designed to capture a vanishingly small number of offenders, potentially as few as 5 individuals. At the highest estimate would be 12 people. And it does seem extraordinary to put in place a unique piece of legislation that does compromise our Bill of Rights, and I'll come to that point later, that inevitably will compromise international agreements and obligations to manage the potentially only 5 offenders. And no one is underplaying the severity of the offending of some of those people, but it's a very peculiar and we think unacceptable way to endeavour to address, to manage the potential release of those people. So we are contemplating legislation, a whole raft of provisions for very few people, as I've said. We have already at our disposal a range of provisions to manage these people. We have mechanisms to manage the risk that they may present at the point where their sentence is complete. And I've yet to hear a really compelling argument or to see particularly powerful evidence that the existing provisions are inadequate to meet the the requirements of public safety around this very, very small number of people who may potentially be released into the community. And again, I would look to the regulatory impact statement and reflect indeed on the outcome of the Stuart Wilson example. The RAS tells us that in all jurisdictions where very high release offenders are released into the community, the police play a major role in preventing reoffending by deploying resources, surveillance and interception of those people, and the resulting detection, I'm quoting now, the resulting detection of breaches of orders and notification requirements or minor offending usually then results in the offender being prosecuted and returned to prison. And clearly that is exactly the case of Mr. Stuart Wilson, who is now back in prison because he failed to comply with the very strict conditions that were imposed on him. And that's, I think, an example that existing provisions are adequate to the cause, or that we have the wit and the capacity to ensure there is a level of public safety, an acceptable level of public safety around the potential release of this very, very small number of offenders. So the point has been made about international examples, and again we can look to the RIS, which is a very useful document. It actually indicates that there are 4 Australian states who have similar provisions for detention or very, very strict supervision orders placed primarily on sex offenders at the end of their finite sentences, and indeed that they may be detained in prison indefinitely or for a renewable finite period. And we're told that the UN Human Rights Committee has already determined that each of those orders breaches the International Covenant on Civil and Political Rights. We are going a step beyond what the Australian states have done. Inevitably, we will be taken to task and to be found in breach of those self-same UN, the Civil and Political Rights agreements to which we are signatories. We're told that this legislation is not intended to be punitive, that it is simply protective. And in that case, withholding that thought, I fail to see how this legislation, the provisions of it, are not punitive. And I'd like just to list the conditions, what is possible in terms of the detention, the ongoing detention of people who have completed their sentence, their finite sentence. These people clearly will be further denied their liberty, their freedom of movement, a most fundamental right of human beings, as we acknowledge that their liberty will be denied them. People may be prevented from sending or receiving written communications under the provisions of this legislation. There may be restrictions on phone calls. They may be unable to make calls or have their calls very seriously restricted or monitored. They may be prevented from receiving visits or communicating orally with people according to the management plan under which they'll be placed. They may be subject to searches within the usual confines of the so-called residence anytime they leave the prison precinct or come back to it, and those searches can include strip searches. They may be placed in seclusion, which I think is a gentle name, or a name that endeavours to differentiate between it and solitary confinement, which is what it would amount to. We're told they may be constrained, that mechanical restraints may be used. Now, I invite anyone to explain to me how those provisions are not punitive. How does that differ in any substantial way from a conventional prison sentence? All this legislation does really is elongate, extend the sentence, the finite sentence that's been applied to these people. How can it in fact be held the legislation in fact does allow for the offender to be kept simply in a prison rather than under the disguise of one of these so-called residences. So the proposition that this legislation is not punitive, that it will not impugn human rights, that it will not contravene our own Bill of Rights Act, despite the dare I say it, rather convoluted semantics of the Attorney-General's report, inevitably this will be found in breach if it goes ahead in its current form. The Greens do not find this acceptable and will be opposing this legislation.
Mr. Speaker. Call Alfred Narrow.
Mr. Speaker,
am constantly concerned when I hear that member talk about the issues and the rights of the offender over the rights of the victim. Mr. Speaker, he actually turned around and said that it was electioneering. Well, Mr. Speaker, if we've gone out and we've said to ordinary Kiwis and New Zealanders that we want to embark on a comprehensive program of reform to protect communities,